welcome. Today is Friday, February the 21st, 2020, and we wanted to jump into some new legislation that actually has come out a little while ago that, based on some of the feedback that I've been hearing, we really wanted to take a look at. And that is this notion of federalism, the 10th Amendment, and what does all this mean? And so to jump right into it, it is actually H.C.R. 16. So this is a concurrent resolution calling for the creation of a National Federalism Task Force. And this is brought to us by Representative Jefferson. Again, the link's down below. To get into it, let's take a look at lines 70 through 73. So pardon me while we read this just for a second. Again, follow along down below. And it says, in the creation of a National Federalism Task Force for the purpose of convening a series of federalism summits to consider and develop plans for restoring and maintaining clearly discernible divisions in the roles and responsibilities of the national government and the states. So as we look at that, we can begin to see what this is asking us to do, right? So it says we want to get some plans to restore discernible divisions and roles of the national government and the states. So let's look at that for a moment. What does that exactly mean? Well, most of the time when people use this language about federalism, the first place that I would encourage all of us to go is to the Federalist Papers. I've got a link below that can give you access to all of the Federalist Papers. Great opportunity for you to go through and see what three of our founding fathers had to say during these Federalist Papers. One of the most important things that we want to look at, though, is actually the 10th Amendment. Now, some of the makers of the Federalist Papers initially were a little bit opposed to the idea of even having amendments to the Constitution, where they felt, no, if it's not in the Constitution, it belongs to the people and the states. If we start putting amendments in, then it opens up this debate about, well, why don't you put everything in? So again, most of the time the founders were pretty clear in thinking, if it's not in the original Constitution, it's not there. But we did get the 10th Amendment, which states very clearly the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are preserved to the states, respectively, or to the people. And to make this even more clear, under Article 3, Section 1 of the Constitution, it describes what authority federal courts even have. And this article limits the federal court's authority to federal laws and interstate suits. Hopefully, for those of you that are listening, thinking, oh my gosh, we have wandered so far away from the intent of the Constitution. And I would agree with you. However, what has me a little bit concerned is when I look at this particular concurrent resolution, I don't really see anything clearly defined. And because it's not defined, it makes me want to immediately start thinking, well, what are their definitions of these type of things? So the first thing I wanted to jump into here is a quote by Thomas Jefferson. If you've never heard this before, shame on you. Write this one down. It's also down below. So Thomas Jefferson said this. He said, the several states who formed that instrument, the Constitution, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a nullification by those states of all unauthorized acts is the rightful remedy. And this was actually part of the Kentucky Resolution. So in here, we find some more words. We see this word called nullification. And oftentimes, if you bring this word up to your legislature, you'll either get one of two things from your legislator. They will say, oh, let's keep talking. This sounds great. Or they may run for the fences and say, oh my gosh, nullification. That's not what we do. That's quasi-anarchy. So again, what is federalism? What is this rightful remedy? What is nullification? I think it's important that we get these things defined. As relates to federalism, very simple. It's the 10th Amendment, ladies and gentlemen. As relates to nullification, let's look at that. If we look at the dictionary today, which I did, I went to dictionary.com and got this amazing description. It says that nullification as described today is the failure or refusal of a U.S. state to aid in enforcement of federal laws within its limits, especially on constitutional grounds. Now, when I read that, I don't know about you, but I find that definition to be extremely narrow. So another definition of nullification presented is that nullification happens when states refuse to enforce unconstitutional federal laws. Again, very limiting in what does nullification mean. So when I use the word nullification, here's what I'm trying to say. So nullification is an act or set of acts, if you will, which has as its end result a particular law being rendered null and void or unenforceable within a particular area. So now that we have that working idea, what is or could be some paths for nullification? Let's look at a few of them. So the first one that I've come up with would be this idea to legalize public defiance. And the way that I could, I guess, bring that to light is look at what's going on with federal laws and the states as relates to cannabis or marijuana. Not too many years ago, without effect, the federal government said no more cannabis, no marijuana whatsoever. And one by one, states have started to enact their own legislation, effectively nullifying a federal law. At this point, we actually have close to 40 states that are very close or have already in some way or another legalized cannabis, Utah being one of those through medical cannabis. The second way is that a state, local, and even the individual could practice non-compliance, and that non-compliance would be a form of nullification. So let's look at another example. So by 1928, there were 28 states that had stopped funding alcohol prohibition enforcement, with local police only sporadically enforcing the law. So one way you could look at this type of nullification is that the laws are not going to go into practical sense. The federal government may have a law, but it's not going to be enforced. Again, think about 1928 with prohibition. So another way is that the feds simply do not have the manpower to enforce all of the federal laws. They are nearly impossible to enforce on the local level unless the local magistrates, the local legislature, and most importantly, the local constitutional sheriff, look that one up, but the constitutional sheriff is the one who would have to enforce that law. So another way to look at this, if you're still not sold on this, well, let's look at Martin Luther King and Rosa Parks. Effectively, they practiced this non-compliance of nullification through the segregation laws. And they did that through civil disobedience. There were laws, they felt that these laws were unconstitutional, and they practiced civil disobedience. The third way would be through state and local interposition. And what this would mean is that state agencies would actually come in and stand between the citizen and the federal government to protect rights. And this could include criminal charges that the federal agents are seeking to enforce a nullified law. So again, another example of this would be the response to the Fugitive Slave Act of 1850. And this was where a number of states actually did this, and they were quite effective with it. Another way would be through jury nullification. Hopefully all of you, if you have the opportunity to be called to work on a jury, let's remember an amazing quote from Alexander Hamilton. In 1804, he said this: "Jurors should acquit even against the judge's instruction if, exercising their judgment with discretion and honesty, they have a clear conviction that the charge of the court is wrong." So what this is saying is that even in the event that a person is found to be guilty of a particular charge, the jury could still nullify that by saying they're guilty, but the charge is wrong. And another way we could look at that is that in all trial of every single criminal case, the jury shall be the judges of law as well as fact, except that the court may pass upon the sufficiency of the evidence to sustain a conviction. And this is actually Article 23 from the Constitution of the State of Maryland. Another one, Article 1, Section 19 of the Constitution of the State of Indiana, says this: in all criminal cases whatsoever, the jury shall have the right to determine the law and the facts. So hopefully we didn't go too quick there. Again, we have some show notes below, but very interesting to consider. What is federalism? What is the 10th Amendment? What did Jefferson mean when he said that nullification, his word, not mine, that nullification is the rightful remedy? The other thing I wanted to touch on, super exciting thing happened today. We'll have to touch on it another time, but we had an amazing Senate Bill 174, and Senator McKay is going to need our help on this one, and it is an actual abortion bill, ladies and gentlemen, and it's called Abortion Prohibition Amendments. The link is below, but this is effectively going to make abortion in the state of Utah illegal with a few exceptions. Those exceptions would be serious risk to the mother, an abnormality that would result in fetal death, rape or incest, and both of those would have to be reported to law enforcement. So, great bill, great stuff going on. Hopefully this helped us to wrap our heads around how it is that we can rein in the federal government in the correct manner, in the manner that those that actually crafted the Constitution encouraged us to do. Have a great weekend, and we'll check in with you on Monday.